Good morning, people. On behalf of Operation Rock, I am Clayton here, back with my second weekly broadcast as promised, and continuing with my series discussing how you, as a private citizen, can hold the police accountable for violating your civil rights. The information I provide today is not legal advice. Let me give my little disclaimer. It's information. It's information to help you do what you need to do when you do come to a point or involved in a situation. Excuse me, I'm just trying to change my security settings. Okay. Or when you are involved, excuse me, in a situation where you are violated by the police. Um, Again, people, it's not right. Law enforcement does it all the time. And as minorities and African Americans, Hispanics, minorities overall, forgive me, I think I said that right the first time. We are constantly violated by law enforcement officials who choose to feel and believe somehow that they are granted rights that are superior to us. Now, in the course of their responsibilities, acting as a cop or a prosecutor or a state official, yes, they do have certain rights that are superior to us, but none of those rights grant them the authority to violate constitutional or state privileges or immunities that we may receive through already pre established law. Let me start out with a couple of things, people. First, again, Section 1983, this section of the United States Code that grants you the opportunity to seek, I would say, justice against law enforcement officials who violate your rights, does not create a right in itself. And what I mean by that is it doesn't create a privilege, this 1983. No, what it is it's specifically designed to help you, a private citizen who is not a cop, who is not a prosecutor, who is not a judge, who is not someone who is involved in law enforcement, who can use the resources of your profession to seek justice. No, this just provides you with constitutional statute and law that allows you to bring an action before the court if someone who is not involved in within the state, I believe the exact expression is acting under color of law, violates your rights. This is what happened to me again, just to give myself a little bit of a back history so people understand why I am speaking. I was falsely arrested and completely defamed and slandered by members of the Richmond County DA's office in conjunction with NYPD officials in New York. And this also happened to me in the state of New Jersey, where law enforcement officials, despite the fact that I had a valid, active, lifetime, complete, no contact restraining order against my obsessed and incredibly crazy ex girlfriend, refused to grant me those rights provided to a private citizen because they felt that my dark skin and my sex, meaning my sex, male or female, didn't grant me those rights. People, these law enforcement officials were wrong. So I decided to educate myself, like I said again, people, because knowledge is power. Um, as a man, and I'm not going to say a black man, I'm going to say a man overall, people, because I believe the bottom line of this has nothing to do with race. The bottom line of this has a lot to do with the respect that people pay, excuse me, to others, equality, basically. Black or white should not determine how much respect you get from law enforcement. You should get that respect simply because you're a citizen of this great country they tell us is so great. Unfortunately, people, we still live in a society that law enforcement chooses to seek out lower classes and certain smaller sects of class-based people in order to prosecute us to fuel their legal systems and actually just fill their pockets. That's the truth. I'm not trying to insult law enforcement, but what I'm saying is the truth, people. Law enforcement is $1 billion industry. Arrest, false reports, all of that support that $1 billion industry. So until we can find a way to shake the system by holding those in the system accountable for the wrongs they do to violate our rights, people, we're going to continue to be violated. Now, in the beginning, when I started off again, people, I was an angry, 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 angry black man. I'll take that stereotype because, people, it was the truth. But I had a right to be angry. I was being horribly lied on and defamed, people. I had been accused of raping a woman, beating a woman that I was incredibly good to and did nothing to. So naturally, that would make anyone angry. I'm going to deviate for a second to talk about something that's all over the news right now, which is the Jay-Z situation. People, as a man who was falsely accused of a sexual allegation, I can tell you with 100% confidence and certainty that the first thing a man does when he is falsely accused is he denies that false accuse. He doesn't attack a lawyer or a prosecutor who's accusing him. If a victim is saying, "Yo, you raped me and I did," people, I don't mean to judge everyone based off of my reactions, but I'm a pretty straightforward, level-headed man. Any man that is accused of raping a woman that he did not rape is going to flip the hell out, because rape is a serious crime. Sexual assault is a serious crime. The first thing you're going to do is defend your position as a man, like, hey, wait a minute, I did not rape or force myself on this woman or act inappropriately. What's bothering me about Jay-Z, people, and I'm a big Jay-Z fan. I love Hope. I grew up in the '90s, people. There's no way I could not love Jay-Z. We all love Jay-Z. But the simple fact of the matter is, people, from the way I see his legal team handling it, it seems more to me that they are attacking the lawyer instead of the allegation of the victim. And that's the most important thing. See, people, because if you can discredit the victim, then you discredit the lawyer. Why attack the lawyer as the lawyer being an ambulance chasing liar or a con artist, whatever this is, if this victim is lying? See, I think that Jay-Z really needs to focus on the victim. And that's just the truth, people. And it's not wrong of him to attack a victim who is lying on him, people, as a man who went through this. This my broadcast go much further than Staten Island, but I'm going to give you a little bit of history about myself again, because the easiest way to speak about what's going on and what I'm trying to teach is to talk about what happened to me. Um, I won a lifetime order of protection against my ex-girlfriend. Law enforcement, to create a false perception that this woman was a victim after I won the trial, charged me with a bunch of false crimes, literally, that had been closed probably a year before they ever charged me, and investigated as false. They reopened them in another precinct, created a fraudulent complaint, and actually arrested me, claiming I was harassing this woman. Even though I had no contact with the woman, they had no proof I had contacted this woman, that I had reached out to her or done anything to her in almost a year. People, law enforcement was so angry with me, a black man who had received this federally protected order against this woman, that they were backing against me to be a victim, that they actually, the NYPD, and I'm going to say his name because I can, Joseph Quirk, an officer within the 120 precinct of Staten Island, actually fabricated a complaint against me to have me falsely arrested for something that he knew I never did. Now, once that happened, law enforcement needed to further discredit me, because remember, people, I had an order of protection against my offender that was lifetime and incredibly serious, because one, it named my child. Two, it additionally ordered that this woman had to stay 1,000 feet away from me at all time, because the judge was seriously concerned that this woman would not leave me alone. I can definitely say today, people, that judge was right. It was right. That woman didn't leave me alone. He was 100% right. But in any event, Staten Island allowed this woman to continue to defame me and gave her resources that propped her up on a platform to add value to her credibility, because there was an order of protection against her. Staten Island knew that order of protection was valid, but what they did was allow this woman to take a podium and before an audience at St. John's University and lie and tell everyone that that order was fake, even though the DA's office of Staten Island and Safe Horizon knew the order was completely valid, and she had just lost the appeal to try to have the order removed. Um, Law enforcement in Staten Island, completely backed by bias and racism, decided to frame me and create and help this woman create a public narrative that would further discredit me as a victim to allow her to get out of the valid criminal action that she was doing against me. Now, people, that was wrong. By the time this happened, I was broke. I didn't know what to do, because I had been paying and fighting charges and everything from this woman for almost a year. So people, when I got down to the last of my money again, I realized that the only thing they could take all the money they wanted from me. And this is something that my late great mother used to tell me: Clayton, you will be robbed in your life out of so much, but the one thing you will never be robbed of is knowledge. So I decided, people, to educate myself, because I really had no choice. And in doing that, I started excuse me, to oh God, I'm losing my speech. I decided to start to study my civil rights. And in studying my civil rights, people, I came across a lot. I'm thankful for what happened to me, people, because the truth of what happened to me is it made me knowledgeable. You have to be thankful to your enemies when they do things that level you up. And although what my ex has done to me has not leveled me up financially yet, it has leveled me up intellectually, because now I understand exactly what the racist component within the legal system of my country is, and what it's surrounded around, and how it's manipulated to oppress me. So, people, before you on my screen, you see a PowerPoint presentation. And what this PowerPoint presentation has before you is the first slide, which is going to help you understand the parameters or the details of a smear campaign. The smear campaign is a series of attempts to damage someone's reputation by spreading negative propaganda or making false accusations. Excuse me. The goal is to discredit the person or group being targeted. A smear campaign can also be referred to as a smear tactic or simply a smear. Someone using information they obtain online which belongs to someone else with the same name as you that should have been added to create an accusation or to falsely label you with something that is not true about you is a smear tactic. Social media has made using smear campaigns and smear tactics a lot easier, people, because now you have access to immediate information. And the worst thing that can happen to you when someone truly wants to hurt you with a smear campaign is for you to have a common name. Because if you have a common name like Jimmy Hent, like let me think of something common, like Robert Brown. There's a million Robert Browns out there, a million of them. Probably been arrested for murder, probably been arrested for rape, probably been arrested for assault. It's not you. But guess what, people? If you have a dedicated enough enemy, they're going to find someone with your name close enough to you to falsely label you with whatever they need to totally smear, discredit, or slander you. Social media smear campaigns and smear tactics are simply defamation and slander and should be approached as such. Gather as much evidence of the fraud as possible and seek civil or criminal action. Civil action, I'm going to be honest, people, is much better than criminal action. And the reason why, people, is because civil action gives you more control of the justice you choose to seek. A lot of times, criminal action is necessary because people are hurt, um, and the opposing party, the defendant, goes so far that he violates someone's physical rights or physical safeties enough that criminal allegations should be applied, because what you're trying to do is remove that person's freedom from going further with the harassment or the criminal activity they're doing. But when you get into a situation where someone's doing things like this with a smear campaign to you, there's not really much the law can do, because the law doesn't consider this to be that big of a crime unless you're incredibly important. If you're a regular, everyday citizen, they don't give a damn about people lying to you. They really don't care about defamation and slander at all. They only care about it when it applies to someone they want to arrest, like a minority male, like a protected class of citizen, a gay man, a lesbian woman, someone who they truly want to arrest. Then if someone who they choose to back goes to the police and tells the police, hey, listen, this person lied on me, then the police, if they get the right biased detective or racist or discriminatory protective, will push that complaint to get you arrested. But for the most part, the police don't really care when you're slandered. Let's continue. How do I go forward on this? I'm sorry, people. This is the first time I am using this new software that doesn't. Okay, I think I just figured it out. There it goes. Am I right? Yes. So we're going to begin, because I've been talking 13 minutes, people. I should have got right to the point. So we're going to start with Section 1983 of the United States Code, which says that every person who, under color of law, any statute, ordinance, regulation, custom, or usage of any state or territory or district or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to their party. And remember that word liable, because that's the whole point of this, to the party injured in an action at law, civil suit. Suit in equity, key, remember that term, suit in equity, liable in suit in equity, or other proper proceedings for redress. So to dumb this down for you, basically what this says is that any person who has a government or state job who who violates a constitutional law, a state law, something that grants you as a private citizen's rights that are afforded to you and protected by the Constitution, then they are responsible to you to pay you in equity financial damages for damaging you and depriving you of those rights afforded to you by the law. That's the easiest way to say it. They're not going to put them in jail. It doesn't create a law in itself. But if someone violates you, let's say, I'm going to use myself as an example again, people, because my life has been horrible the last 3 years. Let's say a prosecutor violates your civil rights. And like I am now, you decide to take it to social media and you decide to spread awareness about the fact that this prosecutor violated your civil rights, may have done something to oppress your free speech because you're speaking about what they did to violate your civil rights. So what this prosecutor does is use false information to bring you before the court, hoping to get an order to stop you from talking about the truthful things this government official did. One, the First Amendment protects your right as a citizen to speak against a government official who you think is wrong. This is why you hear people call Trump a piece of shit. This is why you hear people speak so badly about political leaders, because the truth is, as long as they're not threatening this person with imminent criminal action or imminent physical harm, you can say whatever the hell you want. It's protected by the First Amendment. So when a prosecutor tries to use fabricated information to stop you from speaking about the truth of the allegations that you're making against them without actually dealing with those allegations, and those allegations are proven to be true, what that prosecutor did was use their position, color of law, to violate your rights, your First Amendment protections against freedom of speech. So this is what happened to me with my ex-girlfriend several months ago in Essex County, where this prosecutor used fabricated information my ex created to take me to court, to have me charged with cyber harassment for content I never made. So in doing this, this prosecutor violated my First Amendment rights. Lawsuit. So we're going to go to the next slide. So everyone knows now that Section 1983 is just a means to bring a private action against the police, anyone who works for the government or the state who does something to deny you a right that is established by the state or constitutional law. That is the simplest explanation for it. We're going to move forward. So, establishing a 1983 claim. 42 United States Code 1983, Section 1983 of the Civil Rights Act. Remember, people, I told you that Section 1983 originates from the Civil Rights Act of 1871. And the Civil Rights Act of 1871 was created to oppress the Ku Klux Klan, even though it was created 3 years after the Klan was allegedly disbanded in 1869 by the Imperial Wizard. Section 1983 only provides remedies for the deprivation of rights elsewhere established in the Constitution for federal laws. I've just told you that. Remember, it doesn't create a right. What it does is it grants you a way to get damages because rights that you are afforded as a private citizen have been denied you by someone who works for the state or the government. To establish a claim pursuant to 1983, using 1983, that's the simplest way to break down pursuant to you using 1983, a plaintiff must demonstrate a violation of a right secured by the Constitution and the laws of the United States, and that alleged deprivation was committed by a person acting under color of law. Simplest example, what I just told you. A person, does something to violate your First Amendment freedom of speech, and this person works for the government, you have a 1983 claim. You're falsely arrested, the Fourth Amendment, protections against search and seizures. You're falsely arrested for a crime you didn't do. The detective has information that gets probable cause to lend to the fact that you may have not have done it, but he still arrests you. People, guess what? You have a claim under 1983. This is why when people are falsely arrested, they may sue for malicious prosecution, but that malicious prosecution claim is an extension of the statute I'm talking about right now, 42 United States Code 1983. It's just injected. The malicious prosecution claim is included under the 1983 claim, because basically what you're saying is that this government official maliciously prosecuted you knowing that you could have possibly been innocent. And that's the whole purpose of a malicious prosecution. The whole I would say perspective behind prosecuting, or suing someone for a malicious prosecution. Let's go to the next slide. Okay. Section 19, the history of 1983. I spoke about that a little bit yesterday also, and I said that Section 1983 was enacted on April 20th of 1871 as part of the Civil Rights Act of 1871, also known as the Ku Klux Klan Act or the Force Act, because one of its primary purposes was to provide a civil remedy against the abuses being committed in the southern states, especially by the Ku Klux Klan. So people, it's funny. There have been points in the United States history where even the federal government has recognized that other Others in the government were actively denying and violating the rights of minorities. This is why laws and statutes and excuse me bills like the Civil Rights Act of 1871, the Civil Rights Act of 1964. People think about it. This act was created after the Civil War. Why? Because I'm sorry to say it, racists did not want to accept the fact that black people had been freed and was trying to manipulate the law. Remember, people, the laws were created for the rich. The slave owners in the South were rich. They lost $500 million when the Emancipation Proclamation freed the slaves. So what did they do? They decided to use the Constitution, a loophole in the Constitution in the 13th Amendment, to re-enslave blacks by creating laws that made blacks criminals, thereby putting them under this loophole in the 13th Amendment. In 1964, what was going on? The Civil Rights Movement. Of course, people, again, people in the government, and I'm sorry to say this, forgive me to all of my Caucasian friends, this is not a racial conversation. White people in the government were denying African Americans their equal protection under the law. In states in the South, what were they doing? They were using their resources, connections, families, and friends to provide false testimony and deny innocent citizens, minorities, the equal protection and equal justice under law. So what happened? They create the Civil Rights Act of 1964 that says, okay, since states don't want to acknowledge the fact that these African American citizens are people, what we're going to do is classify them as a protected class. So now we have extra protections if we go into a federal court and we can prove a 1983 claim, and we can also show that there may have been a racial or a bias-based agenda. Boom, people, now you have an element for a 1983 claim. The act was intended to provide a private remedy for such violations of federal law, and has subsequently been interpreted to create a type of tort liability. Basically, what I just said again, people. The number of cases that have been brought under Section 1983 dramatically increased after the Supreme Court's decision in Monroe versus Pape. Monroe versus Pape, people remember that name. That is the first case that was used with 1983 to hold a law enforcement or government official um, accountable for wrongdoing. That's a very important case, people. I'm not going to go into it now because that'll take me another half hour, but Monroe versus Pape is the first case where 1983 was used to hold a law enforcement official accountable for wrongdoing. Now we're going to go to 5 elements of 1983 claim. According to the Third Circuit's jury instructions, a plaintiff must prove both of the following elements by a preponderance of the evidence, which means a substantial favor of the evidential weight has to be in your favor to convince a court, state or federal, that your rights were violated. Now, here's the 2 criteria. One is that the defendant, the person you're suing, acted under color of law, meaning that when they wronged you, they were in their official capacity, whatever their job is, whether they were a family court clerk, whether they were a family court judge, whether they were a criminal court prosecutor, whether they were a criminal court judge, whether they worked inside the DA's office. People, all of these people, even the advocates, from the domestic violence advocates in the DA's office, the domestic violence counselors, the domestic violence lawyers, the program heads, people, they all work for the city. If they work for the city, they work for the state. If they work for the state, they work for the government, and you have a claim under 1983. This 1983, the Section 1983, I believe is particularly important right now to fathers in the United States, because millions of fathers, and I'll say this, I'm confident in this, people, millions of fathers have been violated in the United States by the family court systems of the United States, people. It's a complete trap. It's biased. It's incredibly racist. They do everything they can to deny fathers, and especially minority fathers, and especially people who lack the resources or education to properly defend themselves. They do everything to make the process as complicated as possible, to drag it out so they can continue to be the parasitic organism they are on the municipality and the government they are. The family court system is a complete parasite, people. All they do is drain the resources of the state and destroy the body, the nuclear unit of the family. That's it. So the defendant acted under color of law, and while acting under color of law in their state or in their government or state, official position, the defendant deprived the plaintiff of a federal constitution or statutory right. Constitution is the Constitution, statutory is the state. So while this person was within their job, while they were on the clock, that they deprived you of a right. Whether that right was even to see your child, people, because that's a big one with men in the family court. People, if you have never done anything to your child, if you've never assaulted your child, if there's no physical evidence that you even harmed the mother can make an allegation that has an order of protection put on you. True. The mother can make additional allegations that you may have come to the house and threatened her. But people, those allegations have nothing to do with the child. If you've never done anything to harm your child, if you've actively been a part of your life, then under the protections of the 14th Amendment, the government has no authority to tell you how to raise or any responsibility of what to do with your child. So when they deny you access to your child because of a lie the mother told, they can mediate the domestic dispute between the mother, but they have no legal authority to keep your child away from you from an extended period of time if there's never been an allegation of abuse against you. Abuse is the only thing that stops a father from seeing his child, nothing else. So family courts use these order of protections as leverage to keep children away from their fathers. And they use the laws of the court to try to justify this by telling you that it's the bureaucracy and the backlog of the court. So because the court is inefficient and the court has a year backlog, you're trying to tell me I can't see my child? Absolutely not, people. So guess what? Now we're suing the family court of fucking Brooklyn. Excuse my language. Let's move to the next slide. People, it's been real for me. The last couple of years have been real, but I'm grateful for them, people, because it's made me wise. It's awoken my mind, and it's given me a hunger to fight a different type of war, people. I was more of a person who liked to use my hands. Now I like to use my mouth and my brain. Oh, that sounds kind of low. Pause. Now I like to use my eloquence and my brain. We got to reverse that other one. That sound kind of whoa. That was a pause. All right. So elements of a Section 1983 continue. Every person. Every person means exactly what I'm saying. Every person that is a private citizen. Only persons are subject to 1983. And what that means is a person right in front of you. A state is not a person. A state is an entity. It's supposed to be a person in terms of corporation because the state is a corporation. But in terms of 1983, the law has decided that the state is not a person. And the reason for that, we're going to trace back to, again, that famous Congress of 1871. These wise politicians realized that there was so much corruption within the state municipalities that if they allowed the state to be considered a person, what would happen is once these people began to take people to court for violating their civil rights, they would sue the state. And if they sued the state for enough, the state couldn't pay it. Guess what? The plaintiff or the awardee would end up owning the courthouse. This is why they refused to make the state, or the municipality a person under 1983, because it exposed the assets of the states. Considering this is an act, that grants a private citizen a way to obtain damages from the state. They don't want to make the state a person because now, if you can prove that the state with the cops and the DA were violating your civil rights, because remember the DA together encompass the state, then you could technically sue the state for an amount so sufficient that you could probably own the courthouse. So again, people, these people were incredibly intelligent. What they said is no. For 1983, we're going to say that states are not persons. Therefore, a person can't go and sue the whole state. What you can just sue is that specific state actor who, acting using the power of the state, violated your civil rights. I hope that's a simple enough explanation. Let's go, because we got 20 more slides, people, and I'm going on 30 minutes. Under color of law. That's like I just said, people, while they were in the capacity of their job, while they were clocked in 9 to 5, 9 to 6, if they worked overtime, whatever it was, if when they wronged you, they were using the protections of their job, or their official title, then they were acting under color of law. The traditional definition of acting under color of state law, requires that the defendant exercise power possessed by virtue of state law and made possible only because the wrongdoer is clothed in the authority of the state. People, like when the DA lies and tries to set you up and then seals the case, people, this is why you can't directly go after the DA, because DAs have what's called absolute immunity. People, I am so thankful to this woman who stalked the hell out of me. She has made me an exceptionally intelligent man. So DAs have absolute immunity, people, and what that means is exactly what I'm saying. That a DA, a prosecutor, can do whatever the hell they want to you while they're in that job, and they can legally get away with it as long as you can't prove that they did it to you. And people, it's incredibly hard to prove it because the 13th Amendment, the 13th Amendment is slavery. The 11th Amendment is immunity. The 11th Amendment of the Constitution provides the government's protections of it against being sued. Because basically, again, these wise senators and House representatives felt that if you did not provide the government, the institution, the judicial system, excuse me, protections, then again, the judicial system would be in jeopardy because private citizens like myself would begin to sue and challenge the efficiency of the judicial system. So what they decided to do was again give these prosecutors in the courts immunity to do their job without fear of being sued. Now, true, it's a useful tool because it does allow someone who works for the government to do their job without fear of being penalized if they're wrong. But the protection that's granted by the 11th Amendment is not meant for these people to break the law. That's what cops and DAs do. Cops don't have absolute immunity. Cops have what's called qualified immunity. And qualified immunity grants them certain protections while they're in the investigative phases of investigating crimes. Qualified immunity does not protect them when they file false reports and lie on you. But what they do is the first thing they do, their first defense when you bring them into court is they're going to say, hey, I'm a cop. I got qualified immunity. You can't look at this. Because the truth is they're trying to pose an argument so strong that the judge doesn't even look at the merits of the case to see whether or not they're wrong. And this is how cops have gotten away with violating the rights of minorities for decades, people, by using the protections of the 11th Amendment, district attorneys too, to literally get away with breaking the law. And because they have this absolute immunity, this qualified immunity, this protection of the 11th Amendment, unfortunately, the protections that they have had for hundreds of years have allowed them to totally violate the rights of minorities within this country for the past 200 years. Such actions may result in liability even if the defendant abuses the position given to him by the state. That's what it's saying, people. If you have a state job that does not grant you the right to violate someone's rights, and if that person can prove you violated their rights while you were on your state job, then you are liable for damages under 42 United States Code Section 1983. Again, people, I hope you're listening to me to make the application that is appropriate to you. This is not legal advice. This is just what happened to me, and I'm using the criminal and the family court situations that legitimately happened to me as examples to show you what you can do if, let's say, the family court denies you the right to see your child. If you've never abused your child, people, they are violating your 14th Amendment rights unless they can prove by a substantial, preponderance of the evidence that you are a danger to your child. They cannot do that to you. They did that to me. If you win a crime against someone as a man, as a black man, as an Indian man, and then 3 days later they trump up a case against you because they don't like the fact you're the victim, and the entire case they trump up against you is a lie, people, they have violated your rights. If they receive information that tells them that an investigation is probably false and they ignore that, people, they're violating your due process rights. All of this happens with police and prosecutors. The truth of the matter is, because of this 11th Amendment protection, they get away with it. The only way we can stop this, the only way we can truly stop minorities being murdered, being killed, being sent to prison for decades, is if we learn them the means as private citizens. And you don't have to be a lawyer to know all this, people. You just have to have a basic understanding. And you have to know what the tool is that you can use when you are arrested for something you didn't do, when an allegation is put against you for something you didn't do. This is the way that you get the cops and the DAs who refuse to honor the fact that your rights have been violated to honor your rights. This 42 Section 1983. So let's keep going. The private actor may also act under color of law under certain circumstances, which means, people, it doesn't just have to be within the role, the official role they have. Like a prosecutor's role is to prosecute crimes. So any role, any action that prosecutor does in the course of prosecuting a crime is technically protected under 11th Amendment immunity. Now, if that prosecutor steps out of that role and, let's say, does something administrative, I don't know, I can't think of what an administrative prosecutor function is, but let's say they do something investigative, like they take evidence from you, like they make outside phone calls. Evidence has a chain, and it starts with detectives. A prosecutor cannot can supersede the chain of evidence. If you submit something, let's say you're a victim and you have evidence against your offender, you have to legally submit it to a detective. You can't submit it to a prosecutor. If that prosecutor begins to step out of her role as a prosecutor and accept information from you, then now she has transgressed her role as a prosecutor and an advocate for the state to now an investigator. So her absolute immunity would drop down to qualified immunity. And that makes it a lot easier to attack the prosecutor. As long as they're in the physical role of a prosecutor, people, it's incredibly hard. You can literally know that these people did something to violate the law, and if they're in a court, you can't do anything about it unless you're the defendant and it's a Brady violation. There's some ways, let me not say you can't do anything about it, but people, it's hard as hell. Let's go to the next slide. All right, we're on 8, people. We're really behind, but we're going to make it through this today. Elements of a section 1983 under color of law. A person can act under color of state law, even if the act violates state law. The question is whether the person was clothed with the authority of the state by either using or misusing the authority. And people, that's what I just said in my really, really long description prior to going to this page, so I'm not going to go back into it. State laws means statute, ordinance, regulation, custom, or uses of any state law. I explain that again, people. Clayton's on point. Clearly, I've been doing my homework. I know what the hell I'm talking about. I'm proud of myself. This includes any political subdivisions of state, such as county or municipality, or also any state, county, or municipal agencies. People, family court, ACS, DC, DSS. People, all of these people can be sued under 1983 if they violate your rights. So if you go to social services and the social service worker is playing with your money, people, if you can prove that this woman is doing it, acting in her job capacity because she doesn't like you for a personal reason, she's violating your right to government services and she's liable for a 1983 claim. People, this is the most amazing thing they created, and they created it for us as minorities. The problem is that rich people, intelligent, powerful people, they know how to get us. What they do is they create these laws to benefit themselves because, again, people, this 1983 and the Civil Rights Act of 1871 was not truthfully created to protect minorities and grant us redress for actions being wrong. They were created to give the president power to stop insurrection after the Civil War. That's the total truth of it. It was not meant to truly give citizens a way to redress themselves. There's always an agenda behind something the powerful do. You have to remember that. Like the state action requirement of the 14th Amendment, the under color of state law element of Section 1983 excludes from its reach merely private conduct, no matter how discriminatory or wrong. So, people, again, if this person who wronged you does not have a state job, then under 1983, they are not liable for damages. There has to be someone who worked within the government within your claim in order for it to be a 1983 claim. Now, you can have a 1983 claim against the DA's office and include a private citizen who was part of that conspiracy. Because the thing is, you have to show the court the totality of the case. A good lawsuit, people, is like a good book. It starts with a beginning, a middle, and an end. It includes facts, people. It includes details. It's a very well-written story. This is what I've learned in the last 3 years. Lawsuits ain't a joke, people. Lawsuits are legal ways to communicate wrongs done to a court, even a criminal complaint, in order for someone to seek action using the protections of the court to get justice, period. Liability under 1983 attaches only to those wrongdoers who carry a badge of authority of a state and present it in some capacity, whether they act in accordance with their authority or misuse it. Again, people, they got to have a state job to be liable for damages under Section 1983. You can include other people in that action to substantiate and bolster your complaint, which you really have to do in the state of New Jersey, because New Jersey has these crazy hearsay laws, people, that if you don't have a person named in a lawsuit, any information you provide from that person, unless you subpoena them into court, is known as hearsay and immediately thrown out of the damn court. Crazy. Anyway, let's go to slide 9. Slide 9. The inquiry into the question of action under color of law is fact specific. There we go, people. In the usual case, courts ask whether the state provided a mantle of authority that enhanced the power of the harm-causing individual. People, if a prosecutor, if a cop lies on you, the state and gets away with it, because people, you can't really lie on people and file false documents and get away with it. The only way you can get away with it is if no one holds that person accountable who defrauded the documents or who lied on you. And when cops do this, when cops use their authority to refuse to investigate complaints, the biggest thing I want to say to that, not to deter myself, people, is you hear a lot about people getting falsely arrested. You don't hear a lot about people getting arrested for lying on people getting falsely arrested. That's a big thing. The reason police don't arrest people who file false reports, people, is because they're going to kill their own. They'll kill their own statistics if they start arresting people who file false reports, because the police know 30 or 40% of the police know that 30 to 40% of domestic complaints are false. But people, the amount of arrest they get for that substantiate criminal arrest and the actions, I would say, of a police department. So why would the police department want to stop arresting people who file false reports if you know by arresting them you're going to stop you're going to stop a lot of arrests that are happening, and then B, what you're also going to do is deter people from filing arrests. So now your arrests are going down because you're proving a lot of the arrests are false, and then they're going down even more because now that you're deterring people by charging those who are filing false reports, no new people are filing false reports. So people crime would drop. They can't have that. Cops will lose their jobs. They'll lose overtimes. No disrespect to cops. I get it, people. I'm a man. I got a kid. I got a family. Guess what? You got to take care of your family. So if your hours are getting cut at work and your primary source of income, let's say, is being a cop, you can't afford for crime to go down. You need crime to be up. So of course, when the people come through, this is why police have, and I don't mean to keep jumping, this is why police have quotas. Like they have to make a certain amount of arrests every month, people. This is how they're able to substantiate from the state, from the city, whatever, whoever's paying them, municipality, the state, why they need $30 million to run the police station this year. They have to keep manpower consistent. They have to keep crime under control, people. And what they do is they get to a certain point where everyone's happy so they can make their quota, and they stop. And everyone who knows about law enforcement in the United States knows I'm telling the truth. Law enforcement works off quotas. The quotas help them keep the budgets in the department that keep the departments running. People, it's all money. So, the Third Circuit has found such circumstances to include the following: finding finding of a sufficiently close nexus between the state and the alleged action of the private entity, so that the action of the latter may fairly be treated as the action of the state itself. Now, what they mean by a nexus is a connection, people. What they have to find is you have to prove, and you don't have to prove it 100%. You just have to prove it before the court, so the court sees that there's a connection between what happened to you and what this person with state authority did. If you can prove that connection, people, boom, you got them. So, the finding, a finding that the state created the legal framework governing the conduct. People, I'm going to go to my situation. I was maliciously and falsely prosecuted by a racist prosecutor in Essex County. What she did was create falsified information she received from a criminal defendant that was used to defame and slander the victim and destroy the victim's credibility. Now, people, a criminal defendant is allowed to attack the credibility of the victim, but they can't do it with false information. They can't do it with fabricated information. And the district attorney has a legal obligation to investigate all claims made before the court. What this racist woman did was refuse to investigate the information my ex gave her. My ex's attorney sent an email lying, saying I threatened her and I was a crazy schizophrenic receiving SSI. People, this lying racist white woman ran right to the police and tried to file a report on me. And then when the police told her, listen, he doesn't own the channel, the IP address doesn't trace back to him, she sought a private action by bringing me before the family court of New Jersey and using her authority as a prosecutor. People, I mean, I went into this court. It was 6 district attorneys in family court trying to have me convicted for cyber harassment, all because of the lawsuit I'm filing against the state of New Jersey now. People, my offender destroyed my life. And people, I'm going to be honest with you. I am so thankful for the knowledge I received, because I'm going to make the government pay for it. She could do whatever she wants. I want to make a disclaimer real quick, people. And I've said this several times, people. You have to get to a point in your victimhood where you do not blame your offender, especially if the government is wronging you. Now, yes, true. Your offender might be harassing you. They might be stalking you. They might be doing a bunch of messed up stuff to burn your life apart. But if you have a mind that has a capacity to go higher, you have to look above the problem to truly see the problem. Yeah, you're being harassed by one person, but why are you being harassed at one person? Is it because someone else isn't doing anything? And in my situation, I could have stopped my ex. I could have gotten physical. I could have got girls to fight her or something like that, people, but that didn't work in my favor because she was already using law enforcement. So, people, I had to go to law enforcement. And when I went to law enforcement, and a judge with the authority of the state reviewed a trial, because, people, there was a trial. This woman went to trial, produced over 100 pieces of evidence against me, and the judge was able to determine that she falsified the evidence, lied through her teeth, totally convinced her complaint, and found her guilty of violating the Prevention of Domestic Violence Act and harassment against me. The problem was, people, that again, law enforcement doesn't like black men to be victims. So despite the fact that the court granted me this order for my life, myself and my innocent daughter who did nothing to this woman, law enforcement, in their incredibly biased and racist capacity to be exactly what they have been since the post-Civil War reconstruction of the southern states, decided to use the law to make me an offender so they can keep perpetuating the same sick system of financial slavery and oppression that they have on minorities for hundreds of years. People, that was wrong. And, this is why I learned so much about 1983. I don't want to keep drifting. But again, people, my own situation is enough to educate anybody about 1983 because the things I'm saying actually happened to me. All right, we're going to go to slide 10. In a couple of minutes, we're going to end this because I didn't plan on this going this long. And actually, we'll give it a good hour because this is going to go on YouTube and the rest I'm going to put in the snippet. So everyone will be able to review this. I'll make a link to this. I'll actually post this slideshow online with a link so you can download it so you can see it yourself. Because the truth is, people, the information in this is very useful. You need to know it. It's the only way you'll be able to stop those who act under, color of law, who violate your civil rights. Finding that the private party has acted with the help of or in concert with state officials. People, again, like I just said, you can use 1983 if someone private, like my ex, used a prosecutor like this state prosecutor to help her get revenge on me, and I can prove it. Now I can use 1983. Finding that the action resulted from the state's exercise of coercive power. People, again, this prosecutor received a false email alleging that I was a diagnosed schizophrenic receiving SSI. People, she had a legal obligation to investigate that information. She did. What she did was use it to get me locked out of my ex's trial to help my ex and her attorney get off because of the conspiracy they had to deprive me as an African American male of the rights that the court had previously already awarded me after a trial. Okay, a finding that the state provided significant encouragement, either covert or overt. People, again, I was being stalked for over 2 years. This prosecutor knew it. She knew my ex had taken all the dismissed allegations from Essex County, New Jersey, into Staten Island, into Middlesex County. People, by definition, that's a malicious prosecution. This woman is starting in other places to affect the outcome of the criminal charges she's having in Essex County. But this prosecutor ignored the fact that I was being lied on and falsely accused in multiple places by her criminal defendant, because the truth of the matter is, people, I was a black man. In her mind, in this pig woman's eyes, and that's exactly what I'm going to call her, I didn't have any rights as a black man. She was wrong. A finding that a nominally private entity has been delegated a public function by the state. That didn't happen. A finding that a nominally private entity is entwined with governmental policies, or that government is entwined with a management or control. Didn't happen to me either. Let's go on to the next screen. We're going to go to slide 11. Okay, elements of a 1983 claim. The private plaintiff of a federal right. This is important. By its terms, Section 1983 can be used to remedy the deprivation of rights. When someone deprives you of your rights. The deprivation of rights is when someone denies you a right that you are entitled to. Granted to the plaintiff under the Constitution, federal statutes, and regulations implementing those statutes. So anything, a city ordinance, a parking ordinance, motor vehicle law, people, family court law. When someone acting in any of these state government or city agencies does something to deny you that the laws of that state, city, or municipality or government or the government, you have the right to sue. Period. There's a case in Court versus Ash. The Supreme Court enunciated a 4-part test to determine whether Congress intended to imply a right to sue directly under a federal statute. A plaintiff asserting the right is required to show that 1. Membership in the class for whose benefit the statute was enacted. Okay, so, actually, that's pretty good. That's a good one. So this is how they're saying that Congress intended 1983 to be interpreted. That a plaintiff, the person suing yourself, basically to put forth a right to the court, you are required to show 1, that you are a member of the class to which the statute was intended to benefit. People, 1983 comes from the Civil Rights Act of 1871. The Civil Rights Act of 1871 was created to benefit who? Black people. People, what am I? Black. Okay, so we go on to the next one. Evidence of Congress's intent to confer a private remedy. People, if you read through the Cornell Law Review thesis that I began with yesterday, people, it literally discussed that Congress, in order to quell the oppression and the wrongs being done to minority, at least they say on the record, created the Civil Rights Act of 1871 to grant me, a minority, a private action against people acting under cover of law. So people so far under the test of Congress to assert whether or not I, as a minority male, have a claim under 1983, I have already met two criteria. One, I'm a member of the class that the statute was intended to protect, black people. Two, evidence that Congress intended to infer a private remedy for my rights being violated, 1983. That a right to sue would be consistent with the statutory purpose. People, again, if state actors violate your rights, 1983 gives you a course of action to seek redress against them. People, I'm 3 on 3 so far. Let's go to 4. That the course of action is not one traditionally regulated to the states to a degree that implying their right to sue would appropriate. People, guess what? Fourth criteria met. Because normally people don't go to a state when the state is violating their civil rights, because the state is going to protect itself, people. This is what the states in the South used to do when they used to lynch and burn towns full of black people. The judges, the cops, they would all bury information. The state judges would hide information from the federal government because people, they didn't want the federal government to know the type of terrible stuff was going on within their municipality or jurisdiction. So people, this is why 1983 was created, and by the simple definition of the four-part test that Congress created to imply if someone had the right to sue people, and by the story I just told you, I just hit all four criteria. Let's keep going. The plaintiff must show that Congress intended to grant both a private right and a private remedy. People, again, I've already explained that that was the exact intent of Congress by the creation of the 1871 Civil Rights Act, people, was to create a private citizen need with a means of seeking private redress when the state refused to grant me the protections of the state or the Constitution. People, again, in the years following Court, which is Court versus S, 422 United States 6, page 66, the judiciary becomes less willing to find the rights of action implied directly under a statute. The plaintiffs began turning to Section 1983, the alternative path for enforcing the rights created by the federal law. I'm actually got to read more into that case, people, because I must have missed that. That's interesting. I want to elaborate on that because I can't really speak about that. Okay, 12. In Maine versus Thalbot, the Supreme Court held that the first time that Section 1983 could be used to remedy the deprivation of rights created by a federal statute. Okay, so these are just citing cases that are relevant to the history of 1983 and its proper litigation. In Wright versus Roanoke Redevelopment and Housing Authority, the Supreme Court suggested that a regulation promulgated to interpret a federal statute could also be a law which could be enforced under Section 1983. So, people, again, I told you that a city ordinance, a regulation, a municipal code, anything like that that was created or enacted by a municipality or a state, people, a supervising authority. 1983 can be used to bring an action against them if rights that were conferred upon you by that state agency or whatever are denied you by someone who works there. The initial three-prong test for finding a right enforceable under Section 1983 was set forth in Wilder versus Virginia Hospital Association. It asked whether, one, Congress intended the particular statutory provision to benefit the punitive plaintiff, me. Two, the provision is not so vague or amorphous as to make judicial enforcement difficult or impractical. That's why the language is so simple, people. Again, if any person within a government position or a state position or a city position does something to deny you a right that is in writing prior to the fact that this person did it, they're guilty under 1983. People, that's the simplest way explanation. If you can prove that someone worked somewhere that had to do with the state or government and they denied you a federal or a state right, you have a lawsuit. Okay. The statute imposes a binding obligation on the government, which means that the government has to do something if they determine that this person in their official capacity did something that violated your rights, period. Did Congress create a comprehensive mechanism for enforcing the statute, which implies that it intended to deny a private right of action under 1983? People, that's the three-pronged test that Congress used to substantiate finding if a right is enforceable under 1983. And people, for the most part, they're not playing with the Constitution. They're not playing with the Bill of Rights. They're not states are not playing with the state laws and statutes that enforce it, because this is how they keep us under control. People, that's all what it's about. It's all about control. I'm only halfway through it at 54 minutes. Yikes. We're going to have to do another part. We're going to have to do a part 2A to part 2. Okay. Elements of Section 1983 claims subjects and causes to be subjected, excuse me. Section 1983 does not impose a state of mind requirement independent of the underlying basis for liability, but there must be a causal connection between the defendant's action and the harms caused. So, people, what this is basically telling you is that there doesn't have to be an intentional state of mind like, yo, I'm going to violate this guy's rights. People, they can accidentally do it. And if you can prove it, they're still liable under 1983. You just have to prove the connection between what this person did and how it affected you, people. And you have a legally what's the word I'm looking for? Arguable action using Section 1983 that what the person did. But one, they were employed by the state. Two, what they did violated your rights. That's it. The U.S. Supreme Court has interpreted this causation element to require that the harm be the result of action on the part of the government entity that implemented or executed a policy, statement, ordinance, regulation, or decision officially adopted and promulgated by the body's officers or the result of the entity's custom. Monell versus the Department of Social Services. Let's read that again. The U.S. Supreme Court has interpreted this causation element to require that the harm be the result of an action on the part of the government entity that implemented or executed a policy, statement, ordinance, regulation, or decision officially adopted and promulgated by that body's officers or results in the entity's customs. So, people, what they're basically trying to say there is you have to show that these people have a pattern of doing this, that they have a history of denying people something or violating some rights. This is how the NYPD has been sued so much for stop and frisk people, because they made so many poor arrests and poor decisions in stopping and frisking people that it was really easy when the action was brought before the federal government to prove that they were single-handedly singling out minorities and creating cases for them. Actually, Bunnell versus Department of Social Services had something to do with maternity leave, though. With I believe it was the United Teachers Union or something like that. They weren't paying women for maternity leave, and they were forcing them to go out of work months before they had the baby. So what these women did was get together and said, "Hey, wait a minute, we have rights," and they sued them. And I believe the case was Bunnell versus the Department of Social Services. And the framework for that case provided the legislation where municipalities, and what I mean by municipalities is a city. New York City is a municipality. Newark is a municipality. I'm trying to think of other places. The city of Patterson is a municipality. Los Angeles is a municipality. Any place that's a municipality. Monell versus the Department of Social Services is a landmark case that, at the end of the case, the Supreme Court decided that a municipality could be liable for the actions of its officials if it violated someone's rights. Now, again, you heard what I said earlier, that, oh God, what was I trying to say? That the government, the entity, the agency is not considered a person under 1983. The loophole around that is to take an action under the Monell Clause, because Monell basically states that the municipality can be held accountable not using something called, I think it's called respondent superior, but that's way above the educational level of this video, so we're going to go past that because I don't even want to try to explain that right now. All right, let's go past that. Okay. All right, people, we're going on 2 minutes. So even though we got a lot of useful information today, I have to say that at slide 14, we have to stop because I have to start my day. So people, this was part 1 to my probably 5-part series, which details the fact of how you can bring an action against the police or a prosecutor or a state agency or official who violates your civil rights. It is not an easy task, people. The information I'm giving you is not legal information. I'm giving it to you, hoping that I can expand your mind, wake up your mind enough that you realize what's happening to you. You use some of the points of this video, and you find a good attorney that can help you seek redress and get damages for what these people are doing. Because at the end of the day, people, the only way we can really stop the injustice going on within the family court systems and the criminal court systems is by suing them. This is the only way that we can hold these people who work in the DA's office and the police departments accountable. The people who work for ACS, the people who work for DSS, the people who work for DCYP&P in New Jersey. The only way you can hold a person in a state capacity responsible for violating your rights is using Section 1983. And I'm hoping people, by providing the information I've provided today, it's enough to enlighten someone to use this information to do what they need to do. So, on behalf of Operation Rock People, I will be back in a couple of days with part two of how you can effectively sue the police using 1983, 1986, and 1985, which extend from the Civil Rights Act of 1871. I hope this was informative. Please like, share, and follow people. Follow us on YouTube, follow us on Facebook, grow the community, people. False arrests, the violation by state and government officials is a serious problem. And again, people, activism, screaming from the top of our lungs, calling them racist or bigots or discriminatory people is not going to solve the problem. What's going to solve the problem, people, is finding a legal means to bring these people before courts to hold them, to hold them accountable for monetary damages. Because guess what, people? The government don't like to pay. And if enough people step forward and start suing these people for violating their rights, it doesn't have to be in New York or New Jersey, where I'm from. You can be in LA. You can be in Milwaukee. You can be in Houston. You can be in Florida, people. If you're somewhere where family court or criminal court is violating your rights, then you really need to like, share, and follow this and send it to every person you know this happened to. Because the simple fact is, if you can empower someone by using the information I'm providing to make them, to help them become aware of what's happening to them, then you can affect change in your community, in your area. So, on behalf of Operation Rock People, this was a great, great broadcast. I'm very, very glad I was able to relay some of this information. And I'll probably be back on Saturday because I got some things to do tomorrow. And we'll continue on from slide 14 through 27 and finish part two of how you can sue a police and prosecutor. So, on behalf of Operation Rock People, this was a great broadcast. I love you all. Thanks for watching. Please like, share, and follow. And remember, people, you do not have to be a powerless victim. You can stand up for your rights. And the easiest way to stand up through your rights is through advocacy and education, not violence. So, again, people, on behalf of Operation Rock, this is Clayton signing off. Thank you for watching. Please like, share, and follow again.